So the way it keeps it safer, and we have evidence of this from the other 31 states that have implemented this. So California in 2009, ballot referendum, they went to collecting at the time of arrest. What they saw was the percentage of cases, they're unsolved violent crimes, and we're talking about serious sexual assaults, homicides, carjackings that are in the database. They basically doubled the number of cases where they were getting hits when they moved to doing this at the time of arrest. That stops future crimes. We cite in our letter to the editor a tragic situation where we had arrested and prosecuted someone on a very serious violent crime, but we didn't collect, because it was not the law of the land at the time, the person's DNA. That person was granted pretrial release. While they were on pretrial release, they sexually assaulted someone. What we found out at that time, that when they sexually assaulted the other person and their DNA was ultimately collected, was that they had sexually assaulted someone before we had arrested them for the assault with a dangerous weapon. We had no way of knowing because we weren't allowed to collect their DNA. Had we known that at the time that he was arrested for the serious assault, the second sexual assault wouldn't occur. This is about preventing future crime as well as closing out serious violent crimes that have occurred in the past. So people need to understand how little information is actually collected for purposes of conducting this analysis to see whether there's a link between someone who's arrested and a previously unsolved violent crime. Basically what happens is a technician takes a swab of the inside of someone's cheek, a cotton tip swab goes around, and then that's loaded into a database that's maintained by the FBI that there are incredibly strict rules around. All they are looking at is just a small fraction of the information that's available from one's DNA. You cannot tell anything about the information they use. You can't tell anything about, for instance, the person's even national origin or anything like. We're talking about a very small percentage to see if there's a potential link, and that is all that is going into the system. There are strict rules about who can access. There are rules about removing if someone is subsequently acquitted of the conduct for which they're charged. So there's all kinds of provisions you can put in place to address those concerns. The solution shouldn't be, we're just not going to do it. But where we are today is 60% of all crimes and 90% of our most serious violent crimes, these kinds of crimes, are being charged at the time of arrest. The two issues have nothing to do with one another. We need to have an honest conversation about the value of this. And when you talk about this on the merits without fear-mongering, there's really no argument against it. It is what we said in the op-ed. It is a common sense reform.